Immediately after you de-SPAC and you're an accelerated filer, what are the key provisions of SOX are you going to need to follow? Hi everyone, this is Kim Lay, and in this video, I'll answer that question. So in the case of an accelerated filer and having gone public through a de-SPAC, you have four sections of SOX you have to follow. Section 301, which is the whistleblower hotline, making sure that this applies to all public companies, not just through de-SPACs, but you'll need to make sure that it's confidential, anonymous whistleblower hotline for financial reporting fraud, potential financial reporting fraud. The next section that you'll need to follow is section 302, your first 10K or your 10Q, and every filing after that. You need to make sure there are controls in place for accurate and complete disclosures in your 10K and your 10Q. Section 404 is making sure you've documented and are testing your internal controls over financial reporting. And finally, the fourth one is Section 906 for CEO and CFO certifications. There are more provisions, but these are the key ones that I'm focused on today. So here is an example of an accelerated filer where they have, this is a quarterly filing, and you'll see here there are two parts in section 31 and section 32. There's the certification from the CEO and the CFO for section 302, and then there's the certification for the CEO and CFO for section 906. And so you may ask, what's the difference? Why do you have two certifications? An example of a 302 certification is right here, and this boilerplate language comes directly from the SEC. There are only three things that you're changing on here. That is your name, so I, CFO, fill in the blank, your company, the name of your company, and your signature is, again, your name and your signature. Those are the only places that you can change anything. Everything else is boilerplate language, and you can understand why. From regulators and the law, they want to make sure all companies use the same language, are under the same rule as everyone else, in case there are clever lawyers who've managed to tweak some of the wording to avoid having complete and accurate disclosures. And in this case, there's nothing misleading. You're responsible for making sure that the controls are in place, they're operating, you have supervision. There are various languages around here. And then finally, the section 906 wording, very simple, two lines that say the financial statements are complete. They materially represent all of the facts about the financial condition and the operations of the company. And again, here you have, here's my name, here's the company, and that's it. There's nothing else that you can change here. And again, this is meant to 906 is the provision that says the CEO and CFO could go to jail if they knowingly lie in SEC filings. That's why it's so important. So that covers the four provisions of SOX that you'll need to follow immediately after being a public company and being an accelerated filer. Thanks so much, and talk with you soon. Bye-bye.